So under section 14, when we say the giving of the opportunity to the owner of the goods, all kinds of goods which have been seized, including the conveyance, and it is an important decision whether goods are going to be seized and those are going to be confiscated, whether there is going to be penalty or no penalty. So any such a decision cannot be taken arbitrarily. So proper system, proper procedure has to be followed, and the procedure is, first of all, give a notice. He has been given a notice in writing. Right. This is also very important, because had it been only giving a notice, what does it mean? If it is not there in writing, what will be the implied meaning? If it is not, if the wordings are not there in writing, then what will be the meaning? Even oral intimation will be considered as a notice. Right. That's why it is always there in writing. Now, in the current situation, in writing carries different meanings. It is not saying on paper and writing. Otherwise, tomorrow you will challenge it is on paper, but it is printed. Isn't it? So what is that in writing? So this writing may be handwritten, may be printed, maybe it is electronic or digital communication, but it will amount to notice in writing. So digital things are being recognized over a period of time in all the laws slowly. So when it is silent, it is not saying on paper or anything. So it is implied that digital communication will also be deemed to be included therein. Informing of the grounds on which it is proposed to impose a penalty or to confiscate the goods or conveyance, and to make a representation in writing with a reasonable time as may be specified in the notice against imposition of penalty or confiscation proposed, and if so desired, of being heard in the matter. So no person, no officer under any law can impose a penalty without giving a notice, without giving an opportunity of representation. And here, two types of representations are there. Representation also being asked in, that is also being asked in writing. And when the representation is being submitted in writing, at that time he is required to express his interest, whether he wants to be heard in the matter or not. So if he so desired, right, and if he desires, then hearing is also required to be granted. Okay, read this clause B again. To make a representation writing within such reasonable time as may be specified in the notice against the imposition of penalty or confiscation mentioned, and if so desired, of being heard in the matter. So this is not a matter of discretion of the officer whether opportunity of hearing will be given or not. First part is absolutely essential, that he should be given opportunity of making a representation. At the same time, he should also be given opportunity to make a representation personally if he is interested. If that hearing is refused for whatever reason, tomorrow the whole decision can be set aside. So any section, any law in which procedure is given, that must be strictly followed word by word. Quite possible the officer gives somebody an opportunity of hearing and he's just having a cup of tea and he said hearing is over. But in that case, he has given the hearing. Then you can challenge it other way down, that hearing was given, but it was not a proper hearing. He did not hear anything. He did not take any note, whatever is stated. He did not accept the evidences presented. Then the appeal will go on a different matter. But the question is, if the opportunity of hearing itself is not given, the order is bound to be set aside. Right? So you have to understand these points very, very carefully, that how and when the penalty order can be passed. So when penalty order is proposed, this is the system to be followed. Is it clear? Now, control on export of a specified goods, services, and technology. What are specified goods, services, and technology? Very, very sensitive things. And these are almost prohibited category. So that's why the name given is specified goods, services, and technology. So this may be related to nuclear technology. This may affect relations with the other countries. It may not be in the national interest. All those things can be specified by the government as specified goods or services. And control is on what? It is not talking about import. It is talking about export only. So this whole chapter means 4 sections are there. Everything is about the export. So control on export. What is the real control? Real control is here. This is the real control. Everything is around this only. So no person shall export any material, equipment or technology knowing that such material, equipment or technology is intended to be used in the design or manufacture of biological weapons, chemical weapons, nuclear weapons or other nuclear explosive devices or in the missile delivery system. So in nutshell, in these sections, ABC 14, ABCD, all the things are related to weapons of mass destruction. Weapons of mass destruction, right? Now, 2 years before, there were some questions out of these sections in the exam, and lots of students asked me that they are asking about arms and ammunition. Arms and ammunition governed by another law, right? So here they are asking about the weapons of the mass destruction. Those are governed by 14A, 14B, 14C of the Foreign Trade Development Regulation Act. So many students were asking about that. They are asking about the arms and ammunition. Why they are asking in this arms and not arms and ammunition? These sections. Okay. What is said in? What is the title? Control on exports. Right. There is no talk about import because that is in any case that is prohibited. But for export also. In regard to control on export of specified goods, services, technology referred to in this chapter, the weapons of mass destruction and the delivery system shall apply. Means in nutshell, they have transferred everything to another law. So whether it is import or it is a transfer or it is a export or transfer or retransfer or transit or transmission or brokering, etc. Everything has been transferred to weapons of mass destruction and their delivery system. Right. So it is, simply speaking, it is not governed by this law because that law provides for very harsh penalties on that. And all terms, exemptions or provisions of the weapons of mass destruction, their delivery system, prohibition of unlawful activities, Act 2005 shall apply. What applies? So you can say there are no specific provisions regarding specified goods and specified technology exports. Everything is governed by this law, Weapons of Mass Destruction and their Delivery System Act, you can say. Right? Then, the central government may by notification, the official gazette, direct any of the provisions of the chapter shall not apply to the goods or service or shall apply with subject to certain modification. So where the provisions will be applicable, some exemptions can be granted by the government. So if the exemptions are not there, and if any of the specified goods or specified services or specified technology, export, transfer, retransfer, transit, transshipment, all those things are prohibited. And those will be governed by Weapons of Mass Destruction Act. Okay. Then transfer control. The central government may by notification the official gazette make rules in conformity with the provisions of, so again the same law, in connection with the imposition of controls in relation to transfer of specified goods or services or technologies. So prima facie, it is already prohibited, but wherever allowed. So why it is allowed? It is allowed under 14A itself. This is the subsection. Subsection 3, the government may allow certain exemptions, shall not apply to certain goods, but still those continue to be specified goods and services. So if those are specified goods, then the transfer thereof will be governed by section 14B. So the central government may by notification, the official gazette make rules. Rules for what? For the transfer. In connection with imposition control in relation to transfer of, only transfer, nothing else. Only transfer. Provisions are applicable for export, transfer, retransfer, transit, transshipment, on everything. But here the system is only for transfer. Other words are not there. No goods or services technology notified under this chapter shall be exported, transferred, retransferred, brought in transit, transshipment, except in accordance with the provisions of this law. So if you summarize all the sections 14A, 14B, 14C, what will be the conclusion? That any of the specified goods or specified services or specified technology shall not be exported, shall not be transferred, shall not be retransferred, shall not be transit and transshipment will also not be allowed unless a specific exemption is granted by the central government under section 14A. And if the exemption is not given, then everything will be governed by Weapons of Mass Destruction and the Delivery Systems Act 2005. Catch and all control, this we have already seen that no person shall export any material which can be used for these purposes. So what are these? इन सबको मिला के क्या नाम दे रखा है यहाँ पर? What is the name given to all these things? We have already seen the example of weapons of mass destruction. We have already seen the example of this in last 2 years. Is there anybody who doesn't know this example of biological weapons? Arunji, which biological weapon?
COVID-19 is a biological weapon.
How many people it has killed?
In United States, it is 1 million. In India, it is 6,600,000.
Only 1 million in US.
Only 1 million in US. Yeah.
US figure is this. Worldwide?
No idea.
Without firing a single bullet.
That is biological weapon.
That is biological weapon. Right? So anyway, so all these taken together, what is it is these are referred as weapons of mass destruction. So any of the goods or technology, etc., which may be required for being used, or if he knows that these may be used for these purposes, then he should not. No person shall export. It is a clear-cut prohibition. If he is aware of. Now the question is whether he knows or not. Such material equipment is intended to be, right? Knowing that. So if these are exported for one purpose and those are utilized for altogether different purposes, then nothing can be done. But if there are certain articles which are exclusively used for these purposes, then the prohibition applies straightway. Okay. Then suspension or cancellation of license. This is Director General Officer authorized by him by order suspend or cancel a license to import export of the specified goods or service or technology without giving the holder of. Now this is something important. Till now, whatever we talked about, that whenever any such important decision, then prior opportunity being heard shall be given. But this is a sensitive case. This is about the specified goods, specified services, specified technology, which may be used for weapons, and those are biological weapons, those may be chemical weapons, those may be nuclear weapons, those may be explosive devices, anything. So this is a matter of serious concern. So no opportunity of being heard, but later on it will be given. So it is a suspension. Directly cancellation doesn't come. It will always pass through the suspension. So this is without giving the holder opportunity, etc. But such person shall be given a reasonable opportunity being heard within 6 months of such order on them. In normal courts, opportunity of hearing should come very fast. But here within how much time the opportunity of being heard is being given? 6 months. Right. 6 months is too long a time for such activity. But at the same time, it is something in the national interest. Because the goods or the services or the technology which have been prohibited or in relation to which the license has been suspended, those are likely to be used in the manufacture or production of the biological weapons, chemical weapons, nuclear weapons, or any other explosive devices for the mass destruction. So that's why suspension immediately without giving opportunity, but within next 6 months opportunity shall be given, and thereafter decision can be taken. It may be by order in writing, confirm, modify, or revoke the order. So once opportunity is given, so initially it will always be suspension. Directly revocation doesn't come. So revocation itself or suspension itself means no more further operations under that license. But revocation means it is gone forever. So that will not happen directly. So first is suspension, then comes revocation. Offenses and penalties. So what will happen here? So penalties we already discussed under this side. What are the penalties? We said penalties are minimum fine up to 10,000 rupees, and then it can go up to the 5 times. But whether financial amount is enough when the goods are likely to be used for the mass destruction? So it says no, we are not governing. It will also be governed by weapons of mass destruction and delivery system, prohibition of unlawful activity. So it will also be governed by that only. Right. So even imprisonment, fine, everything, where any person contravenes or attempts to contravene any abates any of the provisions of this chapter in relation to import, export of specified goods, services, he shall, without prejudice to penalty, which may be imposed on him, be punishable with imprisonment for a term stipulated therein. Again, the same law. So everything is being governed in relation to specified goods and technology by the Weapons of Mass Destruction and the Delivery System, Prevention of Unlawful Activities Act 2005. Titles we need to remember, but otherwise everything is being governed by that law. And now this is something important. No court shall take cognizance of any offense under this chapter without previous sanction of the central government. Why this law? Court cannot interfere in anything in this. Why?
It's a matter of national security.
National security, national interest, plus they are aware of our legal system. Isn't it? So once matter goes to the court, means that your next to next generation only is going to hear the judgment of that. Any chances of you hearing the judgment on that? Not at all. Not at all. So here the court cannot interfere on any subject under this, particularly for this chapter at least. So this chapter is about specified goods and specified services, specified technology. Cannot interfere. And as far as any other matter is concerned, now see the appellate system under this act. What is the appellate system? Who has passed the order and where the appeal will go? Any person aggrieved by any decision or order made by the adjudicating authority. Who can be the adjudicating authority? Highest authority is DGFT.
DGFT.
And central government can certainly delegate the powers to the junior officer subject to limitations. So every officer who is authorized to take a decision and to pass the order, he will be referred as an adjudicating authority. So where order is passed by any officer below the rank of DGFT, the appeal will go to the DGFT and his decision is almost final. And where order is passed by the DGFT in the capacity of adjudicating authority, then appeal will go to the central government, no court. Again, court is not there. Two levels are there, and that is the final. Uske aage court nahi hai. There is no court involved in that. So here it says any person aggrieved by any decision or order made by the adjudicating authority under this act may prefer an appeal where the decision or order has been made by the DGFT Director General to the central government. And where the decision or order has been made by an officer subordinate to Director General to the Director General, or to the officer superior to the adjudicating authority authorized by the Director General to hear the appeal. Right. So only two levels of appeal, and the time limit given is within 45 days from the date of the decision order is served on the such person. This date is also very, very crucial. Within 45 days from the date on which the decision or order is served on such person. So it means when it is received by that person, decision already done, it is sent by post but never received. It means the time of 45 days have not begun. Okay. And then on reasonable cause being shown, further extension of 30 days can be allowed herein. So provided that appellate authority may, if it is satisfied that the appellant was prevented by sufficient cause from preferring the appeal within the aforesaid period, it may allow further period of 30 days. So 45 days plus 30 days extension. 30 days extension, it is a discretion of the appellate authority. Usually it is given. Provided further that in case of appeal against a decision or order imposing a penalty redemption charge, no such appeal shall be entertained unless this is a pre-deposit. This is pre-deposit. So I talked about pre-deposit in when we talked about the appeal being filed under the Customs Act by the custom brokers. So there pre-deposit is required. Here also pre-deposit is required, right? So what you need to understand carefully is no appeal shall be unless the amount of penalty the redemption charge has been deposited. Even by mistake, if you mention the word paid, then everything goes wrong. If it is already paid, then why to file an appeal? It is not being paid. It is being deposited, subject to the condition that if the appeal goes against the appellant, amount is already there, it will be adjusted. And if the appeal is decided in favor of the appellant, it will be returned. It will be refunded. So the word is very important. It is deposited, right? So provided further in case of appeal against a decision order imposing a penalty or the redemption charges, no such appeal shall be entertained unless the penalty or redemption charges have been deposited by the appellant. Now in the Customs Act, how much pre-deposit is required?
7.5 at the first appeal.
Yes,
And-
for the first appeal,
and the
7.5% of the penalty. And here, how much they are asking for?
So it's not mentioned. I was just what was
Full amount.
Okay, it's the full amount.
Yes, unless the amount of penalty of the redemption charge has been deposited. Right? The amount of penalty or redemption charges. So full amount is required to be deposited before an appeal can be filed. Only difference is that here appellate authority may waive off the requirement. Under the Customs Act, there is no provision for the waiver of pre-deposit. Provided that where the appellant authority is of the opinion that deposit to be made may cause the undue hardship to the appellant, it may at its discretion dispense with the deposit unconditionally or subject to such conditions. So this kind of provision does not exist under the Customs Act. So how much can be the penalty? Up to the 5 times of the value of the goods or services involved. Right. So it may be 5 crores, it may be 10 crores, it may be 50 crores. And when the appellate authority is having any reason to believe that the appeal may be decided in favor of the appellant, then this kind of exemptions are granted. In general, this is not given. But even when there is a slightest idea or possibility that the appeal goes in favor of the appellant, then this kind of exemptions may be given. So here the pre-deposit is required and here exemption can be granted by the appellate authority. Only one ground, whether it is likely to cause undue hardship. So undue hardship is when money is given, it remains with the custody of the authority until appeal is finally determined. So money gets blocked because there is no specific time limit within how much time the appeal should be cleared. And there's first appeal, there can be next appeal also. The appellate authority, after giving the appellant a reasonable opportunity being heard, if so desires, and after making such further inquiry, that if any, as it may consider necessary, make such order as it thinks fit, confirm, modifying, reversing the decision or order appealed against, or may send the case back to the case with such direction as it thinks fit for a fresh adjudication. What can be the decision? Confirmation, modification, set aside, and it can be sent back. Why the case should be sent back when the appeal is there?
Yes, facts have been left, it not be noted, it can be sent back to the trial.
Proper hearing is not there or hearing is not given. Right? Person has come for appeal, then it is given back to the same officer, follow the procedure and do it again. Right? So if it can be finished up then and there itself, why to come for the appeal? So that right is also there for sending the case back. Provided that order enhancing or imposing the penalty or redemption charge or confiscation of the goods, etc., greater than the value under this section, unless the appellant has been given an opportunity. Now, what is said here? If you're increasing the liability of somebody or reducing his right, then without hearing, this decision should not happen. So hearing is already there before, but before announcing the final judgment, one more opportunity is required to be given, that this is the situation where we are increasing the penalty. So whether appellate authority can increase the penalty than what is given in the order.
So I just had the same question. This increasing of penalty is being done by the initial trial
Appellate
authority.
Appellate
Authority can still increase the penalty.
Yes. That's why you will find that in the notices, amount are random. I'll give you an example.
Then that amount has been deposited will be given back to the appellant, no?
Yes, it will be given back. But there is no appeal then.
Yeah.
Right. So when appeal is there, only then the amount will be kept. So when the case has been sent back, the amount of the deposit will be refunded. Okay. Now see this one. What is said?
Sir, I just have one question regarding this.
Yes, please.
Here it's mentioned that after taking additional evidence, so appellant authority has the authority to take the additional evidence also here.
Yes. Yes.
Okay. Normally, in the normal courts, they don't take evidences for the whatever.
It is a general understanding that additional evidences cannot be taken by the court. No, that is not the case. The fact is that if the appellate authority is satisfied that there was some special reasons which was not presented to the officer, number one. Number two, it was presented but officer neglected for no valid reason, or he has not given a due consideration, then additional grounds are accepted by the court.
Right.
Always, in every law. So the order made in the appellate tribunal shall be final. What is the meaning of this line?
There is nobody about.
There is no appeal, sir.
Yes, there's
No
nothing.
further appeal, no court.
further appeal.
So DGFT is the ultimate authority here. In very rare cases, DGFT is acting himself as adjudicating authority. Then appeal can go to the central government. In 99% cases, the adjudicating authority is not the DGFT, but an officer below them. Review can be done by the central government. So review is another thing. So this is central government in the case of the decision is made by the Director General, or Director General in the case of decision order made by an officer subordinate to. So review means it is examining the decision taken. Why it is examining? Only to check the propriety. Propriety means whether the order given is appropriate in the given situation or not. That is called propriety. So order may be lawful, but it may not be appropriate in a given situation. Right? Say, for example, a person caught for the first time. And that too also, the circumstantial evidence suggests that he has not committed the offense intentionally. And the penalty is imposed at the highest level. In that situation, review will help. So here it is said that who can review? The central government can review as well as DGFT can review. Central government can review if the decision has been given by DGFT in the capacity of adjudicating authority, and the DGFT can review if an order is given by an officer below him. Then he can review. And what can happen in review? In case of any decision order made by the officer subordinate to him, may. Now this is important, may. May means?
On his own. Or can.
It is his duty or it is his right whether they want to review or they don't want to review. This is not an obligation. Otherwise, every order will have to be reviewed. No, it is not. Any order may be taken up for review on its own. Now, how it will be taken up? Government or the DGFT may call the record on their own or otherwise. Otherwise means?
The appellant might want to.
If he is not filing appeal, then he can go for this.
Yes.
Right. Or the time for filing the appeal has already gone, then he can go for this.
And
What
here
is the time for filing the appeal?
he does not have to the money, I guess, here in this case.
Number of reasons can be there because he has not filed an appeal. So call for and examine the record of any proceeding for the purpose of satisfying itself or himself, as the case may be, as to the correctness, legality, and propriety. What is the purpose? What they are checking the order? Correctness, legality, propriety. Propriety, I have given you example. What is the meaning of propriety? So legally it may be appropriate, but it is not in the given situation. Legal error, arithmetical error, those will come in first category, correctness and legality. But propriety means what? Order may be lawful in the situation, but is it appropriate? That is called propriety of such decision order, and provided that no decision shall be varied under this to prejudicially affect the interest of any such person. So it means during the course of review also, the amount of penalty can be increased. Or if there is any refund, that can be reduced. So here it is said, no decision order shall be varied. Varied means amendment, so as to prejudicially affect the interest of the person. So how come the interest is going to be affected prejudicially? If his liability is increased or his right to get the return is reduced. Only two ways. Then no such decision has within a period of 2 years from the date of the decision order received a notice to show cause, etc., and has been given opportunity being heard. So within how much time the order can be reviewed?
Within 2 years.
Within a period of 2 years from the date of the decision order. Right. And received a notice to show cause why the decision order shall not be varied. So 2 years is the maximum time even for passing the order of review also. Right. So this is notice to be given and then opportunity of hearing, then only any such increased liability can be there. So review says that the central government or the DGFT may call the record of any of the proceedings in which any decision or order has been given, either on their own or otherwise. The central government will be adjudicating as a review authority if order is passed by DGFT, and the DGFT will act as a review authority if the order is passed by any officer below him. But the review is purely a matter of discretion. And when the order is taken up for the review, the purpose of review is checking the correctness, legality, and propriety. And if the review is going to have any adverse effect on the person concerned, by which his liability is increased, then no such decision shall be taken unless a notice has been given and opportunity being heard is given. That is section 16. Okay. So what is the difference in appeal and review?
So I have a slight confusion on this. Maybe the
Always
language.
welcome. Always welcome.
So as far as my understanding, maybe I'm wrong. Review is normally it is filed in the same court which passes the original decree.
No.
And revision is with if we go as per the CPC, it is the same court which passes the decree, and revision is called by the higher authority.
This is a
By
review.
the higher court.
No. Now it is what is happening. The central government, in case of a decision order passed by.
Maybe the wording here is, but otherwise, the meaning of review is it's the court which has passed the original decree. It is submitted with the same court.
Correct.
And revision is when the higher court asks for it. But
that
here it is saying
correct.
Yeah.
Actually, in the customs, when we refer this, we'll find that review is done with the objective of filing the appeal. There the revision and review. Review and revision words you will find in the Customs Act. Here the word review itself, it is as good as the revision. Right. In customs, you will find both the words. Review and revision. Right. So review is there also, it is not by the same authority. Review is also by the superior authority, but with the object of filing the appeal. So even senior officer also cannot change a decision. Decision can be changed only by the appellate authority. Here the review itself is a revision.
Sir, when we say the central government, sir, who is the authority to do this, sir?
Under which law it comes? Under which ministry it is?
Sir, finance.
No, this is not finance. The Ministry of Commerce and Industry. Customs comes under the Ministry of Finance.
Okay, sir. And sir,
Okay.
yes, sir. Sir, one more question, sir. When sir in 14, sir, this weapons of mass destruction. There, the last when we say the court cannot take this suo motu recognizance, or the affected party cannot go to the court in this.
Nobody can go to the court, not only affected party. Nobody can go to the court with. So if it is presented to the court will ask for the approval of the central government. Then it can take it up. And the central government will never give this kind of permission.
So, sir, this is not against the fundamental laws or something, sir. This.
Okay. Now, for what, on what topic it is?
Okay, sir.
It's
This
not
is
in general.
Okay.
This is only in relation to weapons of mass destruction, their delivery system, and that is prohibition of unlawful activities. What is unlawful activity? It is an export, which can the export of the material or the technology or the services which can be used for manufacture of biological weapons, chemical weapons, and explosives, etc. Those. So the right is not given to the court. If the court is involved, you understand what will happen. Right? So now we have, under section 15, we have appeals. And under section, we have review. Okay. Now let us compare what happens. Section 15. Appeals. For filing the appeal, first thing required is pre-deposit. Amount of penalty or what is the next thing?
Redemption charges.
Redemption charges. Okay. And this can be unless waived off by appellate authority. On the basis of undue hardship. Order by DGFT. In this case, before central government, and in this case, before DGFT or any officer senior to the officer who passed order, and this is specified by DGFT. What is the time limit?
Right. 2 years.
Time limit for filing the appeal.
45 days.
45 days.
Now below this, any such appeal is required to be filed within 45 days since what?
Order is served. Order.
Since order is served. And on a reasonable cause being shown, extension up to 30 days. Decision may be confirm, modify, nullify order, or send the case back. Penalty increase. And opportunity of hearing. So this is entire section 15. Noted? review. This is a discretionary power of the authority. So this is not an obligation. Any decision order can be reviewed with a view to test, or you can say check, correctness, legality, and propriety. Decision or order can be taken up for review either on its own or otherwise. Order by DGFT and below DGFT. Here review by central government, here review by DGFT. If review is likely to enhance penalty, then number one, notice. Number two, hearing. Done? So after review, we have powers of the adjudicating authority. So these are powers of the civil court. So these are general powers. So we'll not go into the details of this. And then the last thing is protection action taken in good faith, etc., and law gets over. Okay. So this is the Foreign Trade Development Regulation Act. Now, if you go in the beginning, so what is section 3? Tell me quickly. What is section 3?
central government can pass order.
Here it is. Now you can see it here. Okay. So now what is your homework for today? Just remember this list of sections. Right? Remember the list of sections. Tomorrow we are going to do the rules relating to this act. Foreign Trade Regulation Rules 1993. This is the Act of 1992. Foreign Trade Development and Regulation Act 1992. Now, Foreign Trade Regulation Rules 1993. And those rules are in relation to this act only, what we have talked about. How to apply, when to apply for a special license, what is the procedure for suspension, what is the procedure for inspection and entry into the premises, and what is the procedure for seizure, etc. Everything will be there in the rules. So when you are clear about this act, then the rules will become easy to understand. If this act is not clear, rules will not be easy. So remember this list, refer in the notebook, read it again 2-3 times, then we will do the rules. Any questions?
Sir, one practical question can I ask?
Yes.
As was rejected by assistant DGFT, and in
Your
that
voice-
order it was written. Now?
Now I can hear you.
Yeah. ACIS was rejected by assistant DGFT, saying that you can file an appeal under section 15. Now, then appeal was filed to additional DGFT. And that additional DGFT has dismissed the appeal without giving a chance of hearing, saying that order was not in the capacity of adjudicating authority. So you have an option of review under section 16, and this appeal is being dismissed. So if I check the notification of DGFT mentioning the adjudicating authorities under section 13, it has assistant DGFT, and another notification is also there that orders passed by assistant DGFT are to be appealed to additional DGFT.
So where is the main issue? What is the challenge now?
Main issue is we have filed an appeal and they are saying that appeal cannot be made. Go for review. DGFT Delhi.
Did you file that copy of notification with that?
No, now I'll be filing, like replying to that authority with those notifications.
That has to be done.
Yes.
So when you submit that along with the notifications, quite possible they are not aware of this kind of notification. They have said that the adjudicating authority did not have the right, so now you can file the review application. Filing review application is okay. But prima facie, is it a case which goes in favor of appellant?
Yeah.
Right. So if you think that it can go in favor of appellant, then it is better to submit the copy of these notifications. And if they don't entertain, then still you have a right to go for review later also.
Yes.
Right? So review is always there. So review will be more like a complaint that the officer did not have the authority and still he has passed the order.
Okay.
Okay.
So, sorry, I couldn't get, what were the grounds that they rejected the appeal? They didn't, I couldn't get it actually.
Proper hearing not done. It was rejected that the officer did not have the right to pass the order. So officer has passed the order. Appeal is given, appeal is filed. And in the course of appeal, the appellate authority is rejecting that it is not, the officer did not have the right to pass the order. So go for review. Right? Because when the order, when the order itself is not valid, when the officer is not having the right to pass the order, what can be corrected in appeal? So review. In the review, it can be set aside. Right. But when you file these notifications which are authorizing the assistant DGFT to pass the order and additional DGFT to entertain the appeal, it will be accepted. And
Okay.
if not, still you have a right to go for review because there is too much of time for that. How long
Yes.
back it was the case?
Sir, it is of February.
अभी का ही
Appeal
है
was
ना?
filed. Yeah, recent.
हाँ तो अभी है, अभी अपने पास समय है, ये मैटर फटाफट क्लोज हो जाएगा.
Okay, sir.
कर दो. ओके,
Yeah.
तो मिलते हैं हम लोग tomorrow with the rules. Do your homework and we have a meeting tomorrow. Bye bye.
So, good night.
Thank you, sir.
Good night.